What degrees of criminal sexual conduct are there in Minnesota? That's a frequent question that are asked to us lawyers, and I want to educate you about that. In Minnesota, we have 5 degrees of criminal sexual conduct. The least serious is 5th degree, and that by law is defined as a gross misdemeanor, which means the punishment. That means that the maximum punishment is 1 year in jail and a $3,000 fine. It doesn't necessarily mean that you'll go to jail for the whole year, but that's the maximum punishment. It's not a felony. It's still serious, but at least it's not a felony. The typical cases for a 5th degree criminal sexual conduct are either a grab over the clothing of the intimate parts, so that can be like a butt grab, for example, over the clothing. That used to not be a crime in Minnesota, believe it or not, but as of about a year ago, that became a crime here. Or a grab of the breast area or the other intimate parts over the clothing, non-consensual. That is a 5th degree criminal sexual conduct. The other example is masturbating, for example, or exposing your genitals in public. Either one of those would be a 5th degree criminal sexual conduct as well. The next degree, which is more serious, is a 4th degree. A 4th degree criminal sexual conduct means no penetration, but it involves sexual contact, and there are different ways to make it a 4th degree. Sometimes it's by the age difference from the alleged victim, which is called the complainant in the law, and the alleged perpetrator or the actor in the law. So if I grab somebody's butt without their consent, they are the complainant and I would be the actor. So that's what those terms mean. But a 4th degree involves non-consensual sexual contact, and then it's got some other aggravating factors. Sometimes it's an age difference when they're under 16 years old, and it goes from there, and you're a certain number of months older than them. Sometimes it's by using force, and sometimes it's if they're drunk or what they're called incapacitated. And then finally, if there's what's called a significant relationship, such as a parent-child or uncle or aunt and child. A 3rd degree criminal sexual conduct, of course, is also a felony. Now we're getting a little more serious. That involves alleged penetration. And that penetration can come in a few forms. Obviously, it can be in the vaginal area. And what the law says is penetration, however slight, means penetration. So, for example, if we're dealing with the vaginal area, a finger can be penetration. It doesn't have to be a penis. It can be a finger, and that penetration can be however slight, which means even less than 1% of your finger just kind of barely goes into there and parts that area. That's penetration under Minnesota law. It does not have to be fully penetrated, for example. So that's an example of penetration under 3rd degree and 1st degree, which we'll talk about later, criminal sexual conduct. What makes a 3rd degree mostly is penetration, and then you've got some of those other aggravating factors. Again, some of the age difference things that I talked about before, or force or coercion, or someone being incapacitated and things like that. So the main difference between a 4th degree and a 3rd degree is that a 4th degree involves sexual contact, touching even under the clothing, but a 3rd degree involves penetration, and that also can take the form of regular intercourse or oral sex or things like that, of course, or your fingers or things like that. Okay. The next degree is 2nd degree, and that is another one of those degrees that does not involve penetration, but rather involves sexual contact again. So you might wonder, well, wait a minute, 4th degree is already sexual contact. Why would 2nd degree then be sexual contact? What's the difference between those two? And a 2nd degree is more serious than a 4th degree. In fact, a 2nd degree is more serious than 3rd degree penetration. So why does that make sense, for example? Well, usually we're dealing with a couple different aggravating factors there. For example, you can be someone, this can happen even with a butt grab. Let's say a parent is having a sleepover, or their kids are having a sleepover, and the parent grabs the butt of somebody that's under 16 years old without their consent. And also, because it's a sleepover, the parent is in what's called a position of authority. They're entrusted with that kid's care for the night. You've just gone all the way from what would normally be a 5th or a 4th degree criminal sexual conduct up to a second-degree criminal sexual conduct because of those aggravating factors. So there's no penetration here, but because there's some other things going on, they stack them on top of each other, and that makes it more serious. So there are many different aggravating factors that can take place: the position of authority issue, the age, whether, and sometimes the other differences here is if a weapon, a deadly weapon is used, such as a threat with a knife or a gun or something else, or if there's injury to the complainant as well. And injury doesn't necessarily need to be in the intimate parts. The injury can be other places if they're alleging, that they were beat up before or during the act or something like that. So those are some examples of second-degree criminal sexual conduct. The last and most severe form of criminal sexual conduct in Minnesota is a first-degree criminal sexual conduct. Remember, fourth, third, second, and first are all felonies, but what makes a first-degree criminal sexual conduct so serious is the amount of prison time someone faces. Even if they've never been in any trouble in their life before, if you are found guilty or plead guilty to first-degree criminal sexual conduct, you are looking at least of a prison sentence of 144 months, which is 12 years in prison. There are some ways to get around that potentially, but that is the presumptive prison sentence, meaning if you plead guilty or are found guilty, a judge has to look at our sentencing guidelines in Minnesota and presumes that your sentence has to be 12 years in prison. Really serious stuff here, okay? The difference between a second-degree criminal sexual conduct and a first-degree criminal sexual conduct is basically penetration. So take all of the things I just said about a second degree and change it from sexual contact to sexual penetration. So if there's a weapon used, if there's an injury, if there's a position of authority or the age issues or some of the other aggravating factors I talked about, that can change it from a third-degree criminal sexual conduct, which is also penetration, to a first degree. So one thing that sometimes gets frustrating or confusing for people is that prosecutors have a lot of discretion on which degree to charge, especially from a third to a first, since they both involve penetration, and also from a second to a fourth. Sometimes if you can charge a fourth, you can charge a second, and it kind of depends on how hard they want to hit you a little bit. So that's one of the frustrating things that might invoke some due process challenges in your case. And if you have a lawyer that knows how to defend criminal sexual conduct cases, that's something we look at carefully in your case. But that's a basic summary of our 5 degrees of criminal sexual conduct. There are many other smaller parts of each of these laws. It's just it would be a very long video to explain it all. So I wanted to give you the basics today. If you have more questions about criminal sexual conduct in Minnesota, I'm attorney Ryan Pacyga. Feel free to shoot me an email or give me a call. You can find me at arrestedmn.com. That's arrestedmn.com. Or call me at 612-339-5844. If you want to send me an email, I'll send you a free guide back about this. My email is ryan@arrestedmn.com.